Hello, my name is Ryan McCarl. I'm on the faculty at UCLA School of Law, and I've also done quite a bit of tutoring of law students and people taking the bar exam. I wanted to share with you today a few tips for studying for the Multistate Bar Exam, or MBE. First, a few general tips. I think that there's too much material to try to cover everything at once. So I would start with one or two subjects that interest you or that you feel motivated about and try to, as you're doing practice questions, get your question correct rate up to about 50% or higher. So when you actually go to take the exam, by that time, you're going to want to have your percentage correct of practice questions be closer to 70 or 75%. However, when you're just getting started, these are very difficult questions, and it's okay to aim a little lower to aim for about 50% correct. Then once you get to that threshold, what you should do is start gradually adding one new subject area at a time until you're doing all of the MBE subjects. I would study the MBE subjects before studying for the essays. The reason is that the essays quite often will test the MBE subjects as well. I would consider getting a tutor or having a study partner to help you make a study schedule and stay on track. If you can find somebody that has some knowledge of the substantive law that could talk that through with you, that can be helpful as well. The next thing I want to recommend is to do a lot of practice questions, as many as possible, several thousand by the time you take your bar exam, and to create your own outlines as you go. And I want to show you an example of what that process can look like. So the program that I suggest using for practice questions is called AdaptBar, and I don't have any affiliation with them, but I do find that their platform is a convenient way to do practice questions for the MBE. So let's take a look at this practice question. This is from torts. It says, two companies each manufacture pesticide. Their plants are located along the same river. During a specific 24-hour period, each plant discharged pesticide into the river. Both plants were operated negligently, and such negligence caused the discharge of pesticide into the river. A rancher operated a cattle ranch downstream from the company's plants. The rancher's cattle drank from the river and were poisoned by the pesticide. The amount of the discharge from either plant alone would not have been sufficient to cause any harm to the rancher's cattle. If the rancher asserts a claim against the two companies, what, if anything, will the rancher recover? I want to suggest when you answer MBE questions to try to think systematically about the elements of whatever tort or crime or whatever is at issue, and try to avoid relying solely on your intuition, because that will sometimes steer you wrong. I also want to suggest that you always do process of elimination, read every answer choice before answering, and look for explanations of the answer that are incorrect on either the facts or the law, so that you can eliminate that choice. So let's do that in this case, starting with answer choice A. The rancher will recover nothing because neither company discharged enough pesticide to cause harm to the rancher's cattle. So this is getting to causation and fact, the notion being that each company's pesticide or negligence acting alone could not have been a cause and fact of the plaintiff's damages. Okay, so that's answer choice A. B, rancher will recover nothing because the rancher cannot establish how much pesticide each plant discharged. That's a very similar sort of question, answer choice. It goes to problem of proof. Answer choice C is 1/2 of the rancher's damages from each company. This is sort of an intuitive type of answer in which, well, we don't know exactly how much each plant discharged, so let's just split it half and half. But the law doesn't always use intuitive doctrines like that. And then D, the entire amount of the rancher's damages, jointly and severally, from the two companies. And this is going to be the correct answer. And the reason is that when you have two parties that are acting negligently, and the two parties acting together caused plaintiff's harm, then both companies are going to be jointly and severally liable. So the answer is D. So let's give that a try. And that is correct. And its explanation is the rancher's damages resulted from the acts of two independent companies, neither of which alone would have been sufficient to poison the cattle, and in circumstances that make it impossible to determine if either defendant alone caused the injury. This is a concurrent cause of harm, and majority of courts will hold that where the defendant's negligent act unites with another event, the acts of both defendants will be considered the cause of at least part of the harm, and the defendants will be held jointly and severally liable. Therefore, both companies are liable for the entire amount of the rancher's damages. Now, I want to get back to the study strategies. I want to imagine that you got this question wrong or you just weren't sure about it. What I want to suggest that you do is make the most of every question you get wrong by mining the answer explanation for rules that you can plug into your outline. So let's see. So in this case, we can probably mine from this a rule that concurrent acts of negligence, if you have a concurrent acts of negligence in which basically both sides are liable for the entire amount of damages, jointly and severally liable. So try to get that idea or some similar idea of what this is saying into your head, and then kind of step away from your computer for a minute, because you want to be able to put rules to some extent in your own words. You want to make sure that that information passes through your brain instead of acting as a scribe in which you're just taking a rule from one source and plugging it into another. So once you have kind of a grasp of what this rule is getting at, what you should do is then add it to your homemade outline. So let me show you what that would look like. Okay, so we have here a torus outline that I started. So we want to add something about a rule about causation. And let's just put it here under negligence, because that's what we're talking about. So we know that one of the elements of negligence is actual causation or causation in fact, meaning that had the defendant not been negligent, the plaintiff's harm would not have occurred. So that's what this rule falls under. Okay, and the rule is, call it concurrent causes. And we'll say when two defendants' negligence contribute to plaintiff's harm, both defendants are jointly and severally liable for the entire amount of the harm. And just as a aside about that, the policy reason for it is that the defendant should have to find out among themselves who's responsible, rather than putting that burden on the plaintiff, because the defendants have more information about exactly how much pesticide each of them discharged. Okay, so that's what I would do, is make your own outline like this, using rules that you mine from answer explanations from practice exam questions that you've done. You can also add rules from other sources, but the most useful rules to add would be the ones where you got a question wrong or you weren't sure about the answer, because getting a question wrong provides you very useful information in that you now know that you need to study that particular topic a little bit more. Now, once you have an outline like this, what do you do with it? What I would say is you should use it as another tool for passive learning. Passive learning is imbibing through listening or reading information prepared by someone else. And it's not as effective as active learning strategies such as recall and creating your own study tools. However, active learning, while it does is better for long-term retention, is more draining. And so as you're trying to spend hours a day studying, you're going to need a balance of both active and passive learning strategies. Sometimes all you have the mental energy to do is listen to a lecture, for example. So what I would suggest once you've made an outline like this, or as you're making it, is to use an app such as the app called Speechify, which is available for iPhone, and use it to, what it will do is it will basically create an audio file that reads to you whatever you've written. So you feed the Speechify app your document that you've written, and it will then read it to you aloud so that you can listen to it as you drive or run or do the dishes. Other passive learning strategies you can do are to find lectures either through Barbary or on YouTube or there's a company called Sum and Substance, which does audio CD or MP3 lecture series for each of the subjects. Some of them are quite good. And then your remaining passive learning strategy that you can use when your energy is too low for practice questions and recall exercises is to just read. And you can read, obviously, commercial outlines, not just, a lot of people use the ones prepared by Barbary. However, there are other less expensive outlines available from publishers such as Emmanuel's. And you can also use horn books, which are a little bit more detailed explanations of the law in a particular area. And you can use other study aids, such as the Examples and Explanations book series. Okay, so that's all I have for you today. I hope that's helpful. Please let me know if you have any questions.